All right, so next subject is contempt. We're going to talk about that a little different from the way the book presents it. Um, the book says there are four categories of contempt: direct, indirect, criminal, and civil. But I'm going to break it up into two categories with two opposing categories within them. So they're not four varieties, um, but there's direct contempt versus indirect, and there's criminal versus civil. Let's take that up first. The civil contempt involves situations where um, you are ordered by the court to be present for jury duty. You're ordered by the court to testify. You're ordered to do things like that. And if you fail to do so, fail to respond to a witness subpoena, or if you um, respond to a witness subpoena but refuse to testify, the court can hold you in civil contempt, put you in jail to enforce compliance. And what is hoped is the person will relent and agree to testify, and then they're no longer confined to jail, because that's all their confinement was meant to do, was to cause them to comply with the court's orders. Um, but you can be jailed for contempt and be forced to be held in jail for a length of time such that um, it's clear that there's no coercive effect to this to being jailed for civil contempt, and a court has to at some point abandon that practice of jailing somebody because it's not changing their behavior. An example would be Susan McDougal, who was jailed for contempt back in the Whitewater um, grand jury proceedings, or maybe it was a trial that obliquely involved Bill and Hillary Clinton. And she was a friend of theirs from back in Arkansas, and she either didn't know anything or she did and kept her mouth shut and wouldn't testify. I forget which is which. But after some length of time in jail, she had to be released because there was no longer any probable effect in that confinement to her um, changing her behavior and testifying. Criminal contempt is a contempt situation where you violate a court order, um, you know, be it something in a divorce decree, like if you fail to have a child present for visitation, uh, that could be an instance of criminal contempt. And in Alabama, each instance of criminal contempt is punished with 5 days or less of confinement, which is in fact punishment. Civil contempt is not punishment, it's just a means of trying to coerce compliance. But criminal contempt is you're punishing somebody for misdeeds, like uh, the rule against people talking about their testimony outside the courtroom and with other potential witnesses in violation of Rule 615 of the Rules of Evidence. Um, the If you do that, contrary to the judge's instructions to not discuss your testimony with other witnesses, you can be punished for contempt for 5 days in jail for doing that. Now, direct and indirect contempt is a situation where you have contempt that is conducted or committed in the presence of the judge, such as insulting the judge or threatening the judge, that kind of thing. But if the contempt happens outside the presence of the judge, um, then that is indirect contempt. And in those situations where the judge did not observe the contemptuous acts, there has to be a hearing, a notice, and a hearing uh, where the person can defend themselves against that finding of contempt. Um, the book tells you about a famous episode in My Cousin Vinny about contempt and the judge finding Vinny for keeping on talking after he's told him to be quiet and so forth. Another famous contempt situation that is pretty hilarious um, is if you will look up on Lexis or Google the Larry Flint contempt case. Um, it's got a lot of juvenile humor in it, where Larry Flint just goes to this judge and giving him a bunch of time for contempt and wins the appeal on some procedural grounds. But anyway, so the next issue is judicial review. Pay close attention to this figure on page 324. By judicial review, we're talking about appeals. And if you look at the lower left-hand um, corner of that drawing, you've got the conviction in state court, intermediate appellate courts. In Alabama, you have the Court of Criminal Appeals, Court of Civil Appeals, and then you can go to the state Supreme Court and then the United States Supreme Court for review. If you keep going up, the next round of review is state habeas proceedings. We'll talk about what habeas corpus proceedings are in a minute, but this will be Rule 32s, and that can be appealed back up the chain. And then after that happens, if a person is still in custody, they can challenge their detention and their imprisonment with a federal habeas corpus claim. So direct appeal, state habeas, and federal habeas are generally the means by which a trial is subjected to judicial review beyond the appellate judge, or rather beyond the trial judge himself. And after pronouncement of sentence, that's what begins the time for filing an appeal. In Alabama, that is 42 days after pronouncement of sentence. Federal court, I believe, is a shorter time frame, like 14 days. Other states have different time frames. So something that is also done after sentencing and generally before the notice of appeal is filed is a motion for post-judgment relief, like a renewed motion for judgment of acquittal, if you believe that the evidence is insufficient, or a motion for new trial if you can urge the court to recognize that there was an error about evidence that was let in. So you have that renewed judgment of acquittal that addresses a lack of a insufficiency of the evidence, such that a rational juror could not conclude that the person is guilty beyond a reasonable doubt, in which case you're asking the judge to end the case by judgment of acquittal. Then there are those new trial grounds, like challenging a ruling on evidence admission. That situation is really asking for a new trial, not a dismissal. But after that post-judgment motion is filed and then ruled on, either granted, denied, or denied by operation of law, then you appeal, you file your notice of appeal and go to the appellate court. There's some odd timetables in there about when a new trial motion is denied by operation of law and how that begins your appeal time running it's complicated until you see it demonstrated how those timetables work. Just one time, really. Okay, so when a case is appealed, we ordinarily think about going to an appellate court, but remember that misdemeanor appeals are generally handled by by the case being retried in circuit court. So what happens is that you file the notice of appeal with the trial court, in this case the district court for misdemeanors or the municipal court for misdemeanors, and the case is docketed in the circuit court, and a new trial starting from scratch, no presumption of correct rulings in the lower court, no presumption of the correctness of the verdict. You just start from scratch. That's a trial de novo. All right, but ordinarily when you have these trials for error, you have to preserve the issue that you're hoping to appeal. And by that, I would direct you to the contemporaneous objection rule that when you intend to challenge something on appeal, you have to object at the time that the evidence is coming in, and the judge has to make a ruling about that evidence. No ruling, a move on type thing is not a ruling and can't be reviewed by the appellate court. If the court sustains the state's objection, typically, or the defense objection, less typically, you would have to have a proffer of evidence. And by that I mean, if an objection is sustained, you have to be able to show the judge what the evidence is and put that evidence or presumed testimony in the record, or put the docket in the record, not in evidence, but in the record, in order for the appellate court to see what it is you were asking to put in via testimony or via documents. If you don't make a proffer of evidence when an objection is sustained, that evidence, that piece of evidence doesn't come into the evidentiary record. And so you have to make it a court exhibit and describe it, or, provide some short testimony to document what the person was going to say in order to preserve that proffer and give the appellate court something to review. Otherwise, they don't know what you were putting into evidence. There's some discussion of the harmless error rule, and that is like minor surgery. Harmless error is error that didn't happen in your trial. Like minor surgery is surgery that happens to somebody else. Harmless error, it based on the theory that the evidence can be so overwhelming that if you let something improper come into evidence, that its prejudicial effect is overcome by the accumulation of an amount of evidence that just is going to get the person convicted anyway, despite the error. And that's what's called harmless error analysis. All right. The right to appeal is vindicated, of course, by filing a notice of appeal with the trial court. When that happens, the trial court clerk is obliged to put together a record of all the charges, the warrants, the indictment, the motions, the orders, put those into a record, such that there's what is called the record on appeal, that is the official record of the court proceedings. Um, it's the record of the trial from which you're appealing. And, things can't be brought up that aren't within that record. So that's what you're appealing. And the transcript of the testimony has to be prepared, and that can be very expensive unless you are indigent, in which case the state must provide you with a free transcript. But if you have to pay for the transcript of, say, a week-long trial, we're talking about several $1,000s. It can be very expensive and cost prohibitive, really. Okay, so the prosecution can appeal. They can appeal the adverse rulings of the court, and but ordinarily not guilty verdicts, acquittals, those cannot be appealed, and so prosecution appeals just largely have to do with the admissibility or not of evidence. All right. The next subject is habeas corpus. It's what happens, if you're back on page 324, habeas corpus is what happens when, after your direct appeal from trial court to intermediate appellate court to the Supreme Court to potentially U.S. Supreme Court, then you have what is called state habeas corpus, or in Alabama, a Rule 32 petition. It's filed in the trial court, and it is essentially a civil proceeding that provides for a review of what happened in a trial. And there's the potential to expand the record to include evidence of mostly constitutional violations like ineffective assistance of counsel or things like that, there has to be a record created of what was ineffective about representation, investigation effort, and retaining experts, that kind of thing. Ultimately, they're not seeking money judgments, but it is said that it's a civil suit. So a person who is the focus of maybe ineffective assistance claims will often be called to testify about perhaps the existence of evidence, but there were some strategic decisions made about not presenting the evidence or whatever. And that's a separate record on appeal is created based on the evidentiary hearing in a habeas corpus. If a person was deemed to be an ineffective lawyer to have provided ineffective assistance, you have to demonstrate how. And so you may spend time bringing witnesses that should have been called but weren't, putting their testimony and preserving it, and creating a record of what the error was that made the trial constitutionally infirm. Okay? So then federal habeas review is available, and unfortunately, the federal courts are not very powerful with respect to reviewing state court proceedings. Has to be certainly a constitutional issue that is brought before the court that demonstrates that the person did not get a fair trial. Um, you can raise sort of the same kind of issues in federal habeas. The only problem is in 1996, there was something called the um, Anti-Terrorism and Effective Death Penalty Act that streamlined federal review and limited federal review to unreasonable applications of federal law in state courts. Um, if in the trial or in the state habeas, um, there was some kind of egregious misapplication of federal law, the federal court can um, address that. However, the problem is even if um, the, uh, the Alabama courts, the state courts were wrong about something, um, is it the sort of thing that is a gross misapplication of the law, or is there a credible good faith construction of the law within the state? And if the proceedings adhered to sort of those minimum standards and those factual standards um, in a reasonable way, then the federal courts cannot substitute their judgment for um, um, some pretty serious erroneous um, things that can happen in criminal trials. And so the AEDPA is a tremendous hurdle to overcome for any federal habeas corpus petitioner. All right. The I want you to actually read this and sort of take it in. If there is a claim of innocence, there can be circumstances where that may not be good enough. I swear to God, if you read this Herrera versus Collins case, you'll see basically, I believe it is Scalia says that being innocent isn't enough, that over the past, quote, over the past century, clemency has been exercised frequently and in capital cases in which the demonstrations of actual innocence have been made, close quote. So, in other words, he says it's not the court's role um, to correct close cases, that it should only involve the the restrictions and review under the AEDPA, and then if the procedures have been followed correctly, an actual claim of innocence in a procedural posture that perhaps won't permit review or won't permit a successive habeas petition. Those things the court just sort of blithely says has to be the province of the executive branch to grant pardon or clemency, or in the state system, parole. You can be granted um, parole, but ultimately correcting a sentence has to be done by either a pardon or a grant of clemency. Those happen in routine cases, but unfortunately, in close call um, um, cases, um, you're just not going to see clemency granted or a pardon granted. You almost have to do something tantamount to um, to proving yourself innocent. Um, then there are situations where um, the president or governor um, will grant a pardon or clemency if a person admits the crime and then talks about their dramatic reversals and recovery, or their changing of their ways that led to their imprisonment. So, anyhow, I think that though is very naive to think that elected officials like governors or even presidents will grant clemency routinely. Um, in the modern era of the death penalty, I only know of one exercise of executive clemency, and that involved um, Judith Ann Neely, who was going to be Alabama's first woman executed since the resumption of capital punishment with Gregg v. Georgia. And she received a commutation to a life sentence um, rather than a death sentence. And that's a very complicated process that makes it a real outlier in the way pardons or clemency or commutations are granted in Alabama. They just aren't. But that case was special, and sometime if you really want to know, read about it or ask me about it, and I'll tell you some of the things I've heard. But anyway, I don't think that executive clemency and that sort of thing is really an effective check against bad lawyering or bad decisions by judges, um, or even um, a claim of innocence. Uh, it may be rebuffed by both the courts in the case where a situation may be procedurally defaulted, or certainly um, the people who review pardon and clemency applications in governor's offices. Um, okay, I think that's it. And we'll close this out, and that'll be the end of the semester's instruction. Um, just turn in the book reports, be braced for the test next week. And if there are any restrictions about the use of your web browser, like if it has to be done in Respondus lockdown, you'll know that that instruction came from over my head because I told you differently. And I regret that the rules of the game have gotten changed on me in the recent uh, days, really, when I heard about it. So book reports and be ready for the test next Saturday, which I will make available um, um, on Saturday morning. Okay, thank you very much. See you all later.